We shall cover personal law of non-Muslims, just minorities that live in Pakistan. We have Christians, Hindus, Parsis, and Sikhs. Um, so, what other laws do we have? We have Christian Marriage Act 1872 and the Divorce Act 1869, which provide a comprehensive regime for the regulation of personal affairs of Christians. Certain parts of the Succession Act 1925 also apply to Christians. Remember, this act lays down the processes for the issuance of succession certificate. So its procedural parts also apply to Muslims as well as other religious communities in Pakistan. The Marriage Validation Act 1892 supplements the Christian Marriage Act 1872 to validate marriage of native Indians, Christians. The Married Women Property Act 1872 also applies to Christians. Remember, under Christian law before it was reformed, men and women, they were considered as one person. So there was this doctrine of coverture that after marriage, wife's personality merged into husband's personality. That's why a woman after marriage become Mrs. Qureshi or Mrs. Ahmed or Mrs. Rana or whatever. So because her personality merges into the personality of her husband, and the legal implication was that she could not hold property. A married woman could not hold property in her own name. But in late 19th century, this law was changed, and in Indian subcontinent, it was called British India at that time. This act was passed to give married women right to hold property in their own name. We also have Parsis, Hindus, and Sikhs personal laws. So Parsi Marriage and Divorce Act 1936 provides detailed rules regarding marriage, divorce, right of children, personal property, and Parsi matrimonial codes. Very recently, we had Hindu Marriage Act 2017 and Sindh Hindu Marriage Act 2016 in Pakistan. We will look into details both these statutes. The Punjab Sikh and Anand Karaj Marriage Act 2018 provides for solemnization and registration of Sikh marriages in Pakistan, specifically in Punjab. We also have the Special Marriages Act 1872. Please bear in mind that this is an important statute, notwithstanding its age. This act regulates the marriages and divorces of persons who do not profess the Christian, Jewish, Hindu, Muslim, Parsi, Buddhist, Sikh, or Jain religion. The act recognizes that there might be individuals who profess religion in the act or who profess no religion at all. The act envisages multi-religious marriages where each party professes a different religion. The option of this type of marriage, however, is only available to persons who profess Hindu, Buddhist, Sikh, and Jaina religion. Muslim, Christian, Jews, and Parsis cannot enter into marriage with a person professing a religion other than their own under this act. Remember, in India, they reformed their act. They have Special Marriages Act 1954, which allows even Muslims to enter into marriage with non-Muslims. This is how Shah Rukh Khan, Amir Khan, and other Khans got into marriage with Hindu women because they have a different regime in India. The Hindu Marriage Act 2017 was an important development. The act makes it mandatory for parties who intend to enter into marriage that they must be 18 years or above. It also lays down for marriage to be solemnized, the parties must render their free consent. They must not be related to each other within prohibited degree of relationship as per laws, religion, and customs having the force of law relating to Hindus. And neither of the parties should have an existing spouse at the time of marriage. The act declares any such marriage void if the parties are within the prohibited degree of marriage or if they have living spouse. A Hindu husband, however, can enter into a polygamous marriage if his wife cannot conceive a child and is medically declared to be so. Registration of Hindu marriages for facilitating the proof of marriages. The Act lays down rules for registration of marriages with the marriage registrar. The register containing the particulars of marriage is a public document. It remains open for public inspection. However, an omission in marriage register does not affect the validity of a marriage. There is also this concept of annulment of marriage. So you don't seek dissolution of marriage, rather you go to the court and say, my marriage need to be annulled because it was void ab initio. So according to the Act, a marriage may be declared void and may be subsequently annulled by obtaining a decree of nullity if any of the following grounds are met. First, it has not been consummated owing to the importance of the respondent. The parties are below 18 years of age at the time of marriage. The marriage was not freely consented to. The consent of the party was obtained by force, coercion, or fraud, or the respondent at the time of marriage was pregnant by some person other than the petitioner. There are some bars to annulment decree. So this option is not available if the person is presented with, if the petition is presented more than 1 year after force or coercion ceased to operate, or when the fraud has been discovered, or the petitioner with his consent continued to live with the other party as a spouse after the force has ceased to operate or the fraud has been discovered. A petition could also be presented for separation and divorce. So remember, there is this concept of separation, that you're married, but you live separately. We don't have any concept of separation under Islamic law, but Hindu and Christian law have this notion, because remember, under Hindu and Christian law, marriage is a sacrament. It is not a civil contract, so it is not dissolvable. Therefore, they have concept of separation. The Act provides for the judicial separation of divorce between the parties on the following grounds. The petitioner was treated with cruelty. The respondent ceased to be Hindu by conversion to another religion. The petitioner was deserted for a period of 2 years without reasonable cause and without the consent or against the will of other party. And it includes the willful neglect of the petitioner by the other party. The respondent was unsound mind. The respondent was suffering from virulent, incurable, or venereal disease. The respondent renounced the vow by entering any religious order. There has been no resumption of cohabitation between the parties for a period of more than 1 year after the decree for judicial separation or order for restitution of conjugal rights. Sentence of the husband to imprisonment for a period of 4 years, or if the marriage, whether consummated or not, was solemnized before the wife attained the age of 18 years, she can repudiate her marriage before attaining that age. So see, these grounds seem very similar that are provided under Resolution of Muslim Marriages Act 1939. So what's the process for getting a decree? The spouse may file for a decree of termination of marriage with mutual consent on the ground that they have been living separately for a period of 1 year or more because they are unable to live together. The petition under the Act must be filed before the family courts. So our family courts adjudicate on the basis of several religious laws, personal laws. So there are no separate Muslim family courts and Christian family courts or Hindu family courts. So the same family courts, they apply all the laws, but the laws for each religious community are their personal, based on their religious laws. So what's the impact of termination of marriage on a wife and children? Court will take into account. A wife has the right to oppose the grant of the decree of termination of marriage on the ground that it may result in grave financial hardship to her unless arrangements have been made to the satisfaction of the court to eliminate such hardship. The court shall not pass a decree of termination of marriage unless it is satisfied that adequate provisions have been made for the maintenance of the children born during the wedlock. Remarriage, where a marriage is dissolved by a decree of divorce and time for filing an appeal has expired or appeal has been preferred but dismissed, the act allows for the parties to remarry after the expiry of 6 months from the date of the final decision in this regard. Under Section 17 of the Act, a Hindu widow is entitled to remarry after 6 months of the death of her husband. So this is a reformative provision of the Act that allows a Hindu widow to enter into another marriage. However, the most of the Hindu community in Pakistan lives in Sindh, and the Sindh province has its own Hindu Marriage Act 2006. This act simply provides for registration of Hindu marriages. It does not provide any other rules and regulations. There is no reform. So there is this debate then in Pakistan that to what extent Hindu community themselves want their law to be reformed. There is lots of resistance from within the Hindu community against any reform. And when we look into the issue of reform of Christian laws in Pakistan, the same is the case. And now we shall see Christian family law in Pakistan. We have Christian Marriage Act 1872. You can see that this act is very old. It does not cater to the needs of modern requirements of the society, but this is the law. So we have 2000 a judgment of the Lahore High Court where it was held that Christian marriages are monogamous and Christian law does not allow second marriage without divorcing the first wife or unless the first wife is dead. We also have the Christian Divorce Act, which is even older than the Christian Marriage Act, 1869. The act lays down several grounds based on which marriage between spouse may be dissolved, annulled, or spouses may be judicially separated. So annulment, as if the marriage did not happen, void ab initio. Dissolved, marriage happened, but now it is being dissolved. And separation, that you're still married, but you can live apart, right? So these are the three types of separation or a kind of or when parties do not want to live as husband and wife. This act provides that a husband may file a petition for the dissolution of his marriage on the ground that his wife has been guilty of adultery. So under Christian law, if someone wants to dissolve their marriage, they have to prove adultery. So here we see these are the grounds on which wife may file a petition for dissolution of marriage. One is that her husband has converted to some other religion since solemnization of marriage and has gone through a form of marriage with another woman, has been guilty of incestuous adultery, of bigamy with adultery, or marriage with another woman with adultery, or rape and sodomy or bestiality, or adultery coupled with such cruelty as without cruelty would have been entitled to her a divorce mensa et toro, that is divorce from bed and board, that is separation, or of adultery coupled with desertion without reasonable excuse for 2 years or more. Now remember, in 1979, in Pakistan, Hudud laws were implemented, and one ordinance was called the Zina Ordinance, which declared adultery as a criminal offense that could be punishable with stoning to death for married people or 100 lashes for unmarried people. And that law applied to both Muslims and non-Muslims. So a simple divorce case could have become a criminal case in Pakistan. So that's why we did not see many dissolution of marriages happening under this act in Pakistan. However, the option of annulment of marriage was available, and a husband or wife may seek nullity of their marriage through the court if the husband was important both at the time of marriage and at the time of the institution of suit, if the parties were related to each other within prohibited degree of relationship, if either party was insane at the time of marriage, or if the former spouse of either party was alive at the time of marriage and marriage with the same was still intact. The court may also pass a decree of nullity of marriage if it is proved that the consent of either party was obtained by force or fraud. Very similar grounds that are available under Hindu Marriages Act 2017. We have case law. There was Section 7 in the Divorce Act 1869, which provided that the courts in Indian subcontinent will provide the remedy which are adjudicated through UK Matrimonial Causes Act 1973. So in a way, the colonial masters had packed the Christian Act in British India with their act in England. But in 1980, this section was repealed through an ordinance by the Zia regime. And in 2017, a petition was filed before the Lahore High Court, where one Christian person, Amin Masih, argued that Section 7 should be revived, and the Lahore High Court agreed. And they said a Christian couple can invoke Section 7 of the Divorce Act 1869 in order to seek divorce on grounds available under UK Matrimonial Causes Act 1973, including the grounds that the marriage is irretrievably broken down. So now, after reviving this section in Pakistan, courts can apply the Christian law that is being applied in the UK. This is very interesting. When I wrote a case note on this case and sent it to a British journal, they say, "Oh, but our courts apply secular law." Yeah. So this is very interesting that at that time in 1869, when this act was being devised, the lawmakers thought that their courts in England actually apply Christian family law, right? So, and then after this judgment, there was debate about reforming Christian law. There were several bills proposed, but there is a rift within Christian community about this issue, and no legislative instrument has been passed yet. We also have some more case law. So in another case, it was held that a Christian woman's claim for dissolution of marriage should be based on concrete facts supported by reliable and cogent evidence. In another case, it was held that a Christian marriage should not be dissolved on the ground of adultery in the absence of cogent corroborative evidence. So getting divorced under Christian law is very difficult. So we want to leave you with some of these questions about the personal laws of other religious communities in Pakistan. Write a detailed note on the grounds of dissolution of marriage under Hindu, Christian, and Muslim personal laws in Pakistan. Do you think there should be a uniform civil code of family laws in Pakistan? Write a note on personal laws of non-Muslims in Pakistan. Critically evaluate the Hindu Marriage Act 2017 and the Sindh Hindu Marriage Act 2016. Analyze the case law on Christian divorce. Do you think that the judiciary has taken enough measures to reform Christian divorce law and there is no need for further reforms?